Hi, and welcome to the Theater History Podcast. I'm Mike Leager. The Courtroom has long been a reliable setting for playwrights looking to create moments of high drama, from the trial at the climax of Aeschylus's Oresteia to 21st century works of documentary theater that draw from court transcripts. But the connection between theater and the law goes far beyond providing dramatic scenarios for plays. Dr. Luke McDonough has been tracing the connections between the stage and courtroom, and his new book, Performing Copyright: Law, Theater, and Authorship, looks at how copyright law affects dramatic works in the United Kingdom. Dr. McDonough is an assistant professor in the law department at the London School of Economics, who focuses on intellectual property and constitutional law. Luke, thank you so much for joining us.
My pleasure to be here.
We're usually on this podcast speaking to theater scholars or theater practitioners, maybe a little bit of both, but you're coming at this from a different angle, namely the study of law. Could you tell us about the book, about performing copyright, and how the historical and theatrical material that we'll be discussing fits into your larger project?
Sure. My book is a study of authorship and ownership of plays, with theatre in the UK forming the case study. I start in Elizabethan England and I end in the era of contemporary theatre. So the book spans almost 500 years. So it's kind of a grand narrative rather than a micro study. And it's through law, of course, that the play becomes an object of property. And as we all know, objects of property can be objects of dispute, and there can be claims from multiple parties to ownership of such objects. So I trace the emergence of modern copyright law over that long period, exploring how the law affected theatre through new legislation that restricted or empowered theatrical producers at various points, as well as case precedents that helped to define, who is a joint author, what is the work of theatre under law, and of course, a question that I think will be of interest to your listeners, which is, how did theatre affect the law? This is not a one-way relationship. It's actually a very in-depth relationship between theatre and law over several centuries, where there's theatricality in law, and the law is obviously having an impact on theatre as well.
We start in early modern England, and you're talking about this institution called the Inns of Court. You refer to this as early modern England's bastion of legal learning, which sounds very impressive. Can you explain a little bit more about what the Inns of Court were, and in particular, what they had to do with theatre?
Well, the Inns of Court, which still exist today, there are 4 inns in London, Inner Temple, Middle Temple, Lincoln's Inn, and Gray's Inn. These are still the kind of the home, really, the spiritual home, and also the kind of physical home of the bar. So the trade of being a barrister is practiced via the inns. You have to be a member of an inn today in order to be a barrister. But at the time of the English Renaissance, so, we're talking about the reign of Elizabeth I, she comes to the throne in 1558. Around that time, there's a boom in litigation. That means that we need more lawyers, and the Inns of Court is the primary place to train lawyers, and in particular barristers. Obviously today there are many law schools in the UK. There's many routes to becoming a barrister. You still have to be a member of the Inns, but the Inns are not now the only place to study to be a barrister, but they were at the time of Elizabeth I. And what's interesting is that they were seen not only as kind of the lawyer's space, but almost like the third university of England after Oxford and Cambridge, which in some ways at this point are more conservative institutions than the Inns. So the Inns becomes this vibrant, relatively liberal space, not just for learning the law, but for debate and also scholarship and literary activities. Jessica Winston has written this great book called Lawyers at Play, which is about the lawyers writing plays, translating the Latin plays of Seneca and Plutarch, performing plays. And, as I talk about in my book, of course, writing plays of their own, and not only writing plays, but kind of infusing legal rhetoric with Latin maxims and theatrical rhetoric.
Yeah, speaking of writing plays, you mention Gorboduc. What is this, and why is this particular work so relevant to our understanding of the crossover between the legal and theatrical in early modern England?
Well, Gorbodoc is written in 1561 by two lawyers at the inns, Thomas Norton and Thomas Sackville. It was a dramatization of the age-old civil war between the sons of King Gorbodoc, Ferrex and Porrex, who were vying for control of the English throne. But it was also a political commentary on the contemporary succession of Elizabeth I and a contribution to the debate over whether the Queen should marry. For theatrical history, it is a pivotal moment because it is the first English tragedy. And it's written by lawyers, and probably could only have been written by lawyers, because they were the ones at the Inns of Court translating the plays from Latin into English of Seneca, of Plutarch, and other great Roman playwrights. And so it is hugely influential on the later English tragedies, including, of course, those of Shakespeare, which your listeners would be incredibly familiar with. And this is happening, so this huge impact on theatre is happening at the Inns of Court through the writing of English plays and the staging of plays. It's not just the plays of their own that are being staged, but Shakespeare put on plays. Twelfth Night is put on at the Inns of Court. Ben Jonson satirizes the inns in Every Man Out of His Humor. And so we have this acknowledgement from theatre practitioners and dramatists of the inns and a playfulness towards the lawyers. Obviously, in Shakespeare's plays, we also see wider questions like, what does it mean to have a just legal order? Lawyers and the courtroom are often kind of the scenes of dramatic events in classic plays. But this is also something that law internalizes. Let's not forget that law is a performative mode of practice. Lawyers were trained and still are trained in order to develop their own mode of argumentation. They're given a basic text or a set of facts, and they're expected to improvise arguments. And some legal scholars even look at the way judges make their decisions as a form of improvisation. And if you go to a courtroom in London today, you will see barristers perform and speak in a very theatrical way. The rhetoric of English law has been very influenced by the Latin rhetoric of Cicero, of Seneca. But what's fascinating about the Elizabethan period is that it really is a blossoming of both theatre and law. The common law is coming into its own at this point, into something that we would recognize today as a legal system that is open to individual complainants. And of course, theatre, the English drama of the period, is seen as one of the great peaks, if not the great peak of English language theatre. And so this is happening together. The lawyers are writing plays, the dramatists are satirizing the law and the legal process. So it's happening in a very deep and profound way. And that's one of the pleasures of researching this book, was actually, that to me was an interesting discovery. Other people, of course, from theatre studies like Jessica Winston have looked at it, but not that many lawyers like me from the academic law side of things had really spent that much time or thought about how theatre has affected our ways of argumentation. So that's something that I really enjoyed, and I hope that readers of the book will understand and kind of get into in this with the same enthusiasm that I did.
You're talking about how these sort of tenets of English law are emerging at about the same time that some of what we now consider to be sort of the classical works of English drama are also being written and performed. And one of the major figures in that time period is Sir Edward Coke. Why was he so important?
So Sir Edward Coke was a very prominent lawyer and judge. And let's not forget that the common law develops through case law. So judges like Coke are very, very important. They're the ones who push the law forward. And in this early modern period, so kind of the late 16th century into the 17th century, what is now the UK, what was then, Britain, we're not that long before the Act of Union, which is in 1707, so when officially Scotland and England came together. So we're still talking really about the English common law, but it is the root of what we now know as the legal system of England and Wales, which is the major one of the United Kingdom. And so the kinds of maxims and precedents that Cook creates are very, very important. And in particular, at this point in English legal history, the common law is beginning to define in more detail the notion of individual private property, in particular with respect to land, other chattels as well, but land is very, very important here and is very, very political, of course. This is still on the journey that England was taking away from common property, where a lot of property was, you had customary rights if you were a tenant to certain pastures that you had been looking after, or fields that you had been sowing, and that maybe your family had been sowing for generations. And this is beginning to be disrupted. It's an era of disruption in the early modern period that economists and historians have been arguing about for many, many years. But the law is very important here, because where you have a dispute over land, you're going to the court to try to get a ruling in your favor. And the courts are beginning to develop, including using rhetoric borrowed from theatre, Latin maxims, again, like bona fides, malice in se, and so on, are being used in this shift from common property to private property. And it does have an impact on the Industrial Revolution, in the sense that a lot of tenants that held common tenancies that were suddenly being told their legal rights didn't exist, or they were being usurped by private landowners, they had to move to cities, and they end up working in the factories of the Industrial Revolution. And so the common law is developing in this fascinating individualist way. England is not a democracy at this point, but you're beginning to be able to assert legal rights if you obviously will need to have enough money to take a case. So obviously it's the landed gentry that are the ones doing this. But this is, again, it's moving steadily away from the idea that the king is the absolute ruler and can essentially decide what you want. And Edward Coke was one of the judges who began to chip away a little bit at the authority of the crown, and and is beginning to look to Parliament perhaps and to legislation as the source of law, not merely whatever the king has to say. And Coke was certainly familiar with Shakespeare's plays. It's not known for certain whether they ever met. It's a tantalizing idea that they may have. We know that Coke was not a friend to actors necessarily, but he was certainly familiar with Shakespeare, because he did quote from the John of Gaunt speech from Richard II when addressing a crowd during a legal procedure in the early 17th century. And of course, that's reflected by Shakespeare in the fact that The Merchant of Venice, Measure for Measure, and so on, feature legal terms and concepts that Coke was beginning to define. So things like leases, mortgages, pleadings, these begin to take on a concrete meaning at this point in English legal history. And in terms of the plays themselves, we begin to see references in the 17th century to literary property. So the idea that authors should have some sort of property in what they write, and the idea that print publication should not simply be in the hands of the stationer's company, that suddenly becomes very important. And later, adding to this, and within the 17th century philosophy, you have John Locke's theory, which comes a bit later in the century, the idea that you labor towards an artifact, a physical item, or an intellectual item, and you should own what you create. And that ends up being influential on the first British copyright statute in 1710.
So it sounds like there's this idea emerging that something like, say, a play could be property that you could own. Did that mean that Shakespeare and his contemporaries were able to avail themselves of that law, or had it not quite gotten to that point yet?
Well, in a recent episode of the podcast, you discussed, the lost plays from this period, like Love's Labour's Won, which we don't have, and Love's Labour's Lost, which we do. And, one of the fascinating things for me when I was writing this book was looking at how some of the literary and theatrical scholars examined texts and sometimes looking at legal questions, who owned this, who printed it, looking at the register of the stationer's company for records of plays that were printed. And so, a lot of the core archival research in this area has been done by theatre scholars rather than legal scholars, which is really interesting. And the answer to the question is a complex one, as you recently discussed when you were talking about the lost plays. But what is clear is that there were two commodities, I suppose, which involved print on one hand and performance on the other. And we can safely say that the Stationers' Company, which exists, even before 1557, but in 1557 gets its royal charter, and so is formalized as as holding the monopoly on print in England, apart from the universities of Oxford and Cambridge, which have their own separate right. But that's relatively small scale. The Stationers' Company have the right for the rest of England, and essentially it's kind of like a cartel. You have to be a member to be able to print, to have the license to print. And if you manage to get your hands on a text, let's say a play written by a local playwright in London, even if you didn't pay for that from, even if you stole it, or even if you bought it from an actor perhaps who'd been in a production, you could register it as a member of the Stationers' Company, and you could print it. And a lot of plays at this point are not necessarily even being attributed to a single author. And people like Geoffrey Maston have done great work at examining how texts were very unstable at this point, and authorship is very unstable at this point. And so you have this polyvocal authorship where improvisation is happening on stage, and texts are changing from performance to performance, and we have different versions of the plays. One of my favorite examples is, in one version of Hamlet that we have, it says, to be or not to be, that is the question. In another version, it says, to be or not to be, that is the point. So, these texts are changing in minor and major ways as they go through the performance process over several years. And to the extent that they're being printed, they're often being printed without the permission of the main dramatist, like Shakespeare or Marlowe or Ben Jonson. And the money is often going to the publisher and associated sales people and booksellers and so on, but not to the author. On the other hand, then performance is controlled by theatre companies. And this has been discussed on your podcast before. Companies like the Lord Chamberlain's Men and the Admiral's Men, they tried to keep control over performance texts. They tried to hold on to them as much as they could. There's a certain amount of rivalry going on, there's a certain amount of cooperation going on, that they know they're competing in a market. So, at various points, they may be trying to put on the same type of play. At other times, they may realize, actually, if that other company is putting on a tragedy, let's put on a comedy. And that way we will, take that market, let's say. So, they're very much in control of what is known as the performance commodity. And Derek Miller, who's written on this, has looked at this at a later period. But it's very much evident at this period as well. So we have the print commodity controlled by stationers, and we have the performance commodity that the theatre companies controlled. And, the poor old writer is often very distant and often not really benefiting. You might be paying a penny to get into these performances, but the writer might not be getting any of that. Unless, of course, like Shakespeare, you are also a shareholder in the theatre company and you're also an actor. And, you end up having to play these multiple roles within the theatre company in order to ensure that you can get an income. And it's notable that someone like Shakespeare didn't actually put that much effort into getting his versions of his plays published. Instead, they're published in often abridged form. Some of them are not published at all until after he dies, as we know. And so, in comparison with, for example, some of his poetry, which we know he did actually try to get published and did care about presenting it in a form that he'd agreed upon, with some of the plays that we attribute to Shakespeare, we don't see that same kind of care and attention to the print. For him, it does seem as if performance was where the drama was at. And the texts that he was writing or contributing to or adapting were towards that great goal of creating a fantastic performance. And, he can be distinguished perhaps from someone like Ben Jonson. And in the book, I talk about how Ben Jonson has a much clearer view of himself in a self-conscious way as an owner of texts. And he makes a kind of partnership with Philip Henslowe, whereby who is able to get things printed and is a powerful impresario, obviously, at the time, and theatre owner. So is playing both print and performance commodities off against one another. And through Henslowe, he's able to get his versions of the plays printed in the form that he wanted. And there's also an interesting stage element to Ben Jonson, which I talk about a little bit in the book, which is that, it was common practice in the English Renaissance period for the theatre company to refer to the writer as our poet. So the sense of common ownership is it reflected in that term, our poet. We own the poet, he's ours. We're not performing his words, we're very much taking charge here. Whereas Ben Jonson begins to write prologues to his plays that indicate that he is the one who is directing the performance in a way, that he is the one who is in charge as the writer, and it's his words that are being acted out. And so we begin to see Ben Jonson asserting this kind of a role in both in the way that he thinks about print and his own works being printed, and also in the way that he perceives himself and wants to be perceived as the play is being performed on stage. So, in that period, going from the Elizabethan into the Jacobean period, we see that change beginning to occur, where we may be leaving behind towards the end of the Jacobean period, and certainly after the Restoration, we're leaving behind this polyvocal, vibrant, loose, collaborative authorship. And we're beginning to see authors assert themselves. And that's happening at the same time that this idea of literary property is beginning to kind of coalesce within the English law. So it really is a combination of factors and an interesting relationship between law and regulation of ownership by law, and then kind of a market regulation by the various economic actors.
You're citing in your book this distinction made in some previous scholarship between these two different terms, autographic and allographic, two different kinds of works. I'll admit those are totally new terms to me, but that distinction between them seems pretty important, between the autographic work and the allographic work. And it sounds like it's kind of getting a little bit at what you were just saying there about how there's the author who writes the play versus the company that performs it. Could you explain that distinction between autographic and allographic a little more and explain why it matters?
Well, this category comes from Nelson Goodman, the art theorist. He maintained that there was a distinction, or that there ought to be, that we ought to see a distinction between an autographic work, such as a painting that exists in material form, that has a clear original that the painter painted, and that all else is a copy of that. And there are obviously huge debates within art theory about whether those copies are inferior or not. But there's clearly a work that is then copied in some form. And an allographic work, from Goodman's point of view, was one such as a work of music or theatre, which finds its greatest exegesis in its performance. So performativity is very important here when we think about what type of work of art are we considering here? And obviously, music and theatre can be written down in material texts, in sheet music or in a script, but we don't appreciate those types of work of art in their greatest form through that experience of reading the sheet music and reading the script. It is actually in performance that we see those works achieve their greatest kind of sublimity, I suppose you could say. Again, there's a debate about, at what point does reading a play turn it into literature? At what point does performing, let's say, a poem turn it into something dramatic? And so there's an interesting category distinction that makes a lot of sense in certain situations and maybe breaks down in other situations. I mean, some works of pop art may have no clear original, but it's useful to think about from the point of view of someone like me who's doing a legal study, because this fascinating art theory way of looking at the work of art is reflected to some extent in the way the law views these kinds of works. And in the UK, there is a distinction made between these different types of works. For example, a dramatic work like the script of a play must be capable of performance. It is that key aspect that distinguishes it from a literary work. And there has been case law in, for example, the common law world. There's a case involving the old show Opportunity Knocks, which was a kind of performance game show, where a bit similar to American Idol or one of these shows that we would have today, where you would bring your talent to the show and you would demonstrate it. So that format has been questioned by the courts as to whether that can be a dramatic work. And the courts have generally, up to this point, said that it's not, because it's not scripted. There's an element at which you don't know what's going to happen next. Similarly, sporting events have been held, like a football match, for example, has been held to not be a dramatic work, because again, it doesn't have that element of scriptedness. Even though it can be very dramatic, it isn't quite classed in that way under the law. And similarly, a painting, a literary work, a musical work, they all have their own legal definitions. And the legal definitions, to some extent, rely on some of the kind of formal understanding of these types of works within art theory, music theory, theatre studies, and so on. So one of the challenges for me was to try to make sense of all of this, and the fact that when theatre studies scholars come to a text, they will approach it in a different way than when a lawyer will. And even, a literary scholar will probably approach it in quite a different way from a theatre studies scholar. So there are all these different ways to approach the text. And then there are the legal categories. When you need to assert ownership over something, it needs to have boundaries. You need to be able to define what it is you're arguing over. And with something like a work of theatre, that can be very challenging because, certain works of theatre might fit that model very, very well. Think about the works in the more contemporary period of people like Harold Pinter, Samuel Beckett, Martin McDonagh. They tend to be strictly scripted and performed as written. Sometimes that's mandated by either the estate, for example, of Samuel Beckett, or by the playwright himself or herself or their self. And in that sense, those are very like a kind of a work of art that is protected by the law. It has very clear boundaries, written by a single person. On the other hand, collaboration, we talk about polyvocal authorship in the time of Shakespeare. We've got devised theatre today, and we've got forms of theatre that rely on revision in workshops. And so, you might start off with a script written by one person, but you may go through 3 weeks of workshops or more. And at the end of that process, the script may be very, very different. And the input of all of the creative parties will have given something to that final version. And so some of the legal disputes that we have today are about that messy collaborative process and what it produces, and how do we draw the boundaries, and how do we decide who should be the owner of that work.
Yeah, it's so interesting reading your book. It does sort of seem like we've almost come full circle in a way back to, as you were saying, that more polyvocal, many voices go into the creation of a dramatic work. I'm just wondering, just because you cover a lot more ground, we've mostly focused on the early modern period in this interview, but you do cover a lot more ground historically. What are some of the major historical landmarks as we kind of go on this arguably circular path from many different authors, the author isn't that important, on through people like Pinter and Beckett, and now back to this more collaborative playwriting process?
Yeah, I mean, what I can do is try to give a chronology that tries to set up, I suppose, this modern question that we have of how do we deal with collaboration, and how do we try to put boundaries on something that is as boundaryless as theatre. So I've talked about the early modern period, and it's worth going forward a little bit to post the Restoration. So 1660, the monarchy is restored in Britain, and a certain amount of order is restored, I suppose, as well, given that they've gone through a short civil war in England. And what you have is a serious change in theatre production. You now have what are known as the patent theatres. And so the law is regulating theatre in a very profound way from the Restoration onwards. And it's quite different from the kind of vibrant theatrical scene of the Elizabethan period, when you had a lot of smaller theatres. In the post-Restoration period, you have, the patent theatres, which patent in this sense means a monopoly. that you have the right to perform at the Royal Theatre Drury Lane, the Royal Theatre Haymarket, and so on, the Royal Theatre in Covent Garden. But drama is restricted to these 2 or 3 venues in England. As things go on, they begin to widen. So you get the Theatre Royal in Dublin and in Cork and in Liverpool. But serious drama remains very restricted at this point. And what that does is that it ends up creating a situation where perhaps some writers who would have gone into drama end up going into the novel instead in the late 17th century. And so, the Restoration theatre that we have that has stayed with us and that we still perform today, they tend to be fairly frivolous comedies from this period. We don't have the great classics of English theatre at this point. What we do have is a scene where playwrights are beginning to assert themselves, where they do engage with these patent theatres. And once we get to the early 18th century and we have the Statute of Anne, that makes a big difference because authors are mentioned in the Statute of Anne. And this idea of literary property, which had been kind of under the radar in the 17th century, and authors hadn't really been able to define or really bring into play in court actions. Suddenly, they are named as the key parties in the statute. The copyright comes from them and is tied to them in terms of its renewal. After the initial period of 14 years, you can renew the copyright if the author is still alive. And so even though at this point, the mechanics of publishing are still owned by the stationers and the publishers, the booksellers, authors are beginning to become a really important part of this. And they begin to assert their rights over, for example, unlicensed print versions of their plays. But importantly at this point, and Derek Miller in his episode on this podcast went into much more detail than I will at this point. So I'd really encourage anybody who wants to know more about the detail of this period, go back and listen to that episode because that it stands alone in its own right. But it's only print that's protected. We only get to protecting performances in the 19th century. And so we go through a long period where if you can get hold of a theatrical text, you can perform it without the permission of the author, but you can't print it without the permission of the author. So authors are beginning to get control over print of their plays, which they did not have before. And that is important. And in the 19th century, then we get acts in 1833 and 1842, which essentially give the right of performance to authors, to dramatists. And they can now control the performances of their work. But interestingly, these rights are separate legal rights at this point. So going back to this term work, so obviously this term work is used very loosely in art theory, in theatre studies, and so on. What is the work? Well, it's what the playwright has written, or it's what has been performed. Well, in law, the term work, in terms of copyright work, has a very specific and very important meaning. And in the period before the 1911 Copyright Act of the United Kingdom of Great Britain and Ireland, but it's an imperial piece of legislation, the 1911 Act. So it is the first and basic Copyright Act still to this day of Canada, India, Israel, South Africa. Essentially all of the British colonial territories at this point are subject to this law, and it becomes the foundational copyright law for several of those countries. Even if they've replaced it today, some of the concepts and models are very similar in their current present law. And so this term copyright work only becomes an official part of UK law in 1911. And copyright work in that modern sense, which we understand today, is a bundle of rights. And some of your listeners who have published their own works will know this, that they have the right under copyright to perform their work, to publish it, to adapt it, to license it in all sorts of different ways. So copyright is not just one right, it's a bundle of rights in this modern sense. But as author, you own all of these rights and you can sell them or license them as you wish. Up until 1911, these were separate rights, actually. So the right of performance was a separate right, protected legally, than the right to print. And it was only certain dramatic pieces, as they were defined in legislation, that could avail of this performance right. And what that meant, which I talk about in the book, is that you had some perverse kind of shenanigans going on within the theatre industry. And people like Charles Dickens got very annoyed when people put on unlicensed versions of their novels as plays and tried to claim this right. And so by the end of the 19th century, it's becoming untenable. And Bram Stoker pays the Victorian actor Henry Irving to perform Dracula as a stage work for just 2 paying customers, just so that he can claim this dramatic performance right. So it's all becoming very untenable at this point, which is why in the 1911 Act, they eliminate all of this messy separateness that you have with these different rights. And instead, the author is given one right. And if you write a novel, your right of adaptation gives you the right to prevent other people from, let's say, making a play out of your novel and not paying you for that privilege or not asking your permission. So legally, that period that I go through is really interesting for the way in which the individual author comes into focus in the Romantic period in particular. The market begins to reward individual authors, and plays are, up until the early 20th century, when you have cinema and then television and radio taking away attention from theatre. But up until that point, from Elizabethan England up until the early 20th century, theatre is the main public form of art. And when literacy is not very high at various points in this period, people can still enjoy performances of plays. So it's really profound, and obviously is heavily censored as well, which is another fascinating way in which the law interacts with theatre. But it obviously is not the focus of my work. I'm focusing really on that journey that takes us from Elizabethan England up to this contemporary period. And I'm certainly a fan of theatre today, and I'm a fan of devised theatre. And some of the examples of that I look at in my book were prompted by my own fascination with the idea, when you see a work that seems so profoundly collaborative and yet only has one named author and copyright owner, what questions does that make us ask ourselves, both as fans of theatre and as lawyers?
Yeah, you lay out in your first chapter that the main focus of your book is, and I'm quoting you directly here, how copyright actually relates to the creative practices of artists in the realm of theatre in the UK. So given all the history that we were just talking about, did you reach any conclusions about that relationship between copyright and creative practices? And did understanding the history behind it help to shape those conclusions?
Understanding the history is very important. There's no doubt about it. But I didn't want that to be the only thing that I was doing in this book, because, as I said, I'm also a fan of contemporary theatre. And, I'm not somebody who necessarily thinks the classics are the only show in town. I want to see something new. And, some of the works by, in London, Simon McBurney is the head honcho of Complicité. Some of the works of Complicité have been some of the most enjoyable theatrical productions I've ever been to. And there's lots of other companies, like Forced Entertainment is another one in the UK. Devised theatre is a really strong part of the UK theatre scene. So what I did was I did it as properly academic as I could. I got ethics approval, and I followed the ethnographic practices and so on that you have to do if you're doing empirical research. But really, what that amounted to was 20 fun conversations that I had with people who were actually involved in theatre, which in my day-to-day life, I'm not. I'm an academic. I write, I teach, and so on. So the people I spoke to were writers, playwrights, directors, actors. There were also some producers and others, a couple of choreographers I also interviewed. But one of the fascinating things, even about chatting to them, that I discovered was that not that many people in theatre play only one role. That actually lots of people I interviewed said, well, I'm primarily a writer, but I've also done a bit of acting. Or, I'm currently an artistic director, but I spent 20 years as an actor or and so people had multiple roles, and so had multiple insights that they could give me into what it's like to run a theatre, what it's like to start the process of writing a play, and what it's like to collaborate with multiple different parties. And one of the fascinating things that I determined from my analysis of the responses was that there isn't a one-size-fits-all approach that you can take as a lawyer, that you do actually have to look at each play and the way it was written and the way that it was performed on its own terms. And so where you have a dispute, I'm sure some of your audience will be aware that a couple of years ago, there was a quite significant dispute involving the play Tree, which was performed at the UK Manchester International Arts Festival in 2019. It was officially credited to Kwame Kwei-Armah and Idris Elba. Obviously, Idris Elba is a famous Hollywood actor as well, but he was involved in the writing of this play. But two women who had been involved in the writing of that play early on, Sarah Henley and Tori Allen Martin, made a claim that in the media, they were interviewed by the BBC, they were interviewed by The Guardian, that they had been essentially cut out of the project, having been important co-authors at the beginning, having developed storylines, characters, and so on that were reflected in the final version of the play, and yet they weren't credited. And obviously in my interviews, they're all anonymized, so I'm not going to give you specific, I had to give that freedom of anonymity to the interview, so I can't give you specific examples. But suffice to say, and that they're detailed in the book, there are also examples in my interviews of people who felt they should have been credited for input that they gave to a play during a collaborative process. That might have been important character changes during a workshop. It might have been entire lines of dialogue or other significant input. And so these disputes do happen under the radar. But unlike in the 19th century where, as I said, theatre was the main primary form of public art, there was a lot of money in theatre at that point, and a lot of case law. Today, a lot of theatre is subsidized and doesn't make that much money. Obviously, it does at the high end, at the West End, Broadway, and so on. It does make a lot of money. But you probably have 90% or more of theatre that loses money or just about breaks even, no matter how artistically brilliant it is. And so you don't have any financial incentive to take a court case, because it's going to take your time and your money to do that. And so most people will not actually go through that process. But that doesn't mean that legal disputes are not happening under the radar. And this play Tree was one of those examples where the two women playwrights essentially said, we can't afford to sue. We're not going to do that, but we're making our claim in the media, and we want our story to be told. And they blogged about it and so on. So that case study is out there, and I was able to use that in my book as a prominent recent one. There is one case in the last 20 years in the UK that went to the High Court, so a very expensive venue to litigate. You're talking about hundreds of thousands of pounds of legal costs if you lose. And that involves the play Stones in His Pockets, which some of your listeners will be familiar with, which is this play that was originally put on in Belfast. It's a funny play for me to read, being originally from Ireland, because it's about the kind of Hollywood idea of Ireland versus the reality, and the way that that's played with in the text of the play and in the way that it's performed. So it was put on in Belfast in 1996. It had a short run. It was a success. And then, like most plays, everyone thought, well, that's the end of that. We'll move on to the next project. But in 1999, the writer Marie Jones revised it and put it on again. And it became this enormous financial success on Broadway on the West End. It still gets revived today. The director, who was Pamela Brighton, felt very strongly that she had contributed a great deal to that play in two respects. First, she had faxed, and this dates it to the mid-90s, she'd faxed some notes to Marie Jones to start off the process with a kind of character scenario of an opening scene. And that was used by Marie Jones in the way that she approached the final version of the script that was performed. And then in the workshops, Pamela Brighton said that she had added a lot and changed things. That meant that the text as performed and the final version of the text as it went on to Broadway later on had taken from a lot of what she had added. But the court in 2004, when this came to the High Court, in the case of Brighton and Jones, actually did not decide in the favor of the director. The court was very much of the view that they took a kind of literary writerly focus, which is that the script is what matters. Who's doing the writing? It's the playwright. And so what matters for copyright is what the playwright does. And what the director is doing in the workshops, it might be something akin to an editor, but it's not an author. But they did acknowledge a certain amount of limited right for the initial text that was faxed over to Marie Jones, but not the more significant content that had been added during the workshops. However, there's another precedent, and I'll conclude with this one because it brings us right up to date to 2021. There's a precedent from early this year, which follows on from a 2019 UK Court of Appeal case involving the film Florence Foster Jenkins. Again, some of your listeners may well have watched this film. Meryl Streep is in it, Hugh Grant. It was moderately successful. It's about an opera singer who has ideas above her station. The court case is Cogan and Martin. And Julia Cogan, who was herself an opera singer, claimed that she had been a co-writer of the script in its early stages. Nicholas Martin, the defendant, was was the only one credited as the author in the original production of the film. And they'd been a couple during the early stages, and they'd broken up during the process of writing it. So I don't know if you've seen that film Marriage Story, but there's a great courtroom scene where there's a divorce going on, and one party says to the other, I deserve half of his genius because I contributed to it while we were working on this together. And it's a little bit like that. So it was obviously an acrimonious dispute. And after they broke up, Nicholas Martin then essentially cut Julia Cogan out of the project and finished the script by himself. This was then this legal saga that went to the Court of Appeal and ended up being retried at the Intellectual Property Enterprise Court in January of this year and decided in her favor. So Julia Cogan was awarded a 20% share in the script because she could demonstrate through various drafts that she had added certain important character changes, certain lines of dialogue, and so on. And that amounted in the court's view to 20% of the script. And so, that precedent may change the game for collaborators bringing these kinds of cases forward. The Stones in His Pockets case would have put them off from taking a case because it was very clearly focusing on the rights of the writer. This case over Florence Foster Jenkins will probably encourage more claims by collaborators. And it may lead within the theatre industry, which is still very writer heavy in some ways, to acknowledging the importance of collaboration in the way that plays go from an initial script to a final performed version. And we see that even in some of the financial agreements that have come to light in recent years. For example, Lin-Manuel Miranda agreed to share a small portion, though of a massive amount of royalties, with the original cast of Hamilton, because of what they added and what they brought out of what he had written. And so he doesn't share the credit necessarily, but he's sharing a portion of the money with that original cast who were there in the workshops and who were there while the play was kind of in gestation, and whose interventions may have been crucial to turning it into, a masterpiece. And so, I'll conclude with that kind of tantalizing point, which is that we may see more case law because of these recent disputes. And under UK law, a film script and a script of a play are both seen as dramatic works. So the legal precedent is entirely applicable here. So we may see more legal cases, but we may also see more reflection within the theatre community about whether, this individualistic approach is truly the way forward, or where there was a play from about 5 years ago at the National Theatre in the UK called Blurred Lines, where the writer Nick Payne shares the authorship of a play with the director, and they share the copyright. So there may be more of that in the years to come, more acknowledgement of collaboration, not just in a kind of general informal sense, but also perhaps in these formal legal categories of, well, in the end, who gets to be an owner and who gets to control the work, and of course, who gets any royalties that are generated in such a lucky case when your play or the play you've worked on goes on to become a financial success.
Just one last sort of personal note, I guess. We've been talking throughout this whole interview. You're coming at this from the lens of legal scholarship. You're not, first and foremost, a theater studies person. What's it like trying to bridge those two different worlds in your work? And do you think theater people, broadly construed, performers, people who study performance on the one hand, and then on the other hand, scholars from other disciplines. What do you think those two sets of people might gain from working more often with one another?
I think we would all gain from working with one another. And I think we would probably find, certainly lawyers would find points of commonality with the way that theatre practitioners work. I do think that there's some theoretical and category differences that are hard to get past. It was certainly a challenge for me because some of the theatre studies literature can be quite dense, and each area of scholarship produces its own jargon, and lawyers are certainly as bad at producing jargon as other scholars can be. But I do think that the best scholars of theatre studies, someone like Geoffrey Maston, for example, who's worked for such a long time on Shakespeare and polyvocal authorship, I really enjoyed reading his view, and he was interested in quasi-legal categories. Someone like Derek Miller was very interesting for me to read because he's someone who comes from a theatre studies background, who ended up writing a very legal-focused book, his book on performance and copyright. Whereas I'm a lawyer who's come to write a book which is about theatre and is very enmeshed in the theatre studies world. And during the lockdown of 2020, I spent a lot of time reading this material. And as I said, it really was a pleasure when you read the great scholars of any area, though also a challenge, because as I said, getting through some of these dense books and dense articles was not easy. But I certainly think that we need to keep talking to one another. And this podcast I found to be a really useful resource. For example, when I was doing the early stages of my research, as someone who's not trained in theatre studies, I had to learn a lot of it on the fly. And something like your podcast is a really interesting way in for someone like me who's a lawyer, because you tend to tease out from the interviewees the crucial points about a certain area. And so, for example, as I said, the recent discussion you had over the Lost Plays brought up a lot of these questions where, you talked about, well, who would have owned that text and so on. But at no point did you mention copyright, I don't think, in that conversation, whereas our conversation is very much focused on it. And there's value to both, and there's relevance to both. And I think that in terms of my future research, I'm certainly interested in maintaining this conversation with people outside of my field. And I know the book will be reviewed by Theatre Journal. I know that's in the work. Someone's going to review it there. It's going to be reviewed by law journals as well. I'm very interested to know how different people with different perspectives come to the book and react to it. And I have a certain amount of there's the great line from Shakespeare, which is first kill all the lawyers, right? So there's this sense within theatre, which I love, even though I'm a lawyer. Maybe I'm a self-hating lawyer. Maybe that's why I love it. But I love the subversive nature of theatre, and the fact that theatre can be a space for interrogating a political consensus, and it can be a space for polemics, and it can be a space for challenging the status quo and challenging the powerful. And the law, although it can be a tool for challenging the powerful, intellectual property law and copyright law is often not a tool for challenging the powerful. It often is the tool of the powerful. And so, I'm interested to see whether that view that I have of theatre, which maybe someone in theatre scholarship would say that's too idealistic, perhaps, and maybe they have a very idealistic view of the law. Who knows? But I'm interested in this reaction, and I'm really hopeful that people in theatre studies read the book. I'm doing the Substack series, which I'm making as accessible as I can, and also the first chapter, which contains a lot of the key ideas of the book, is available for free online. So please download that. It's on SSRN. It's on the publisher's website. And if you're curious as a listener of this podcast and you go and read that chapter or any of my other books, please do get in touch, because I want this conversation that we're having today to lead me to other interesting areas, and we'll see where it goes from there.
We'll post links in our show notes that will let you explore Luke's research into the history of copyright and drama, as well as more information about his book, Performing Copyright: Law, Theatre, and Authorship. Luke, thank you so much for joining us.
Thank you.
If you'd like to continue today's conversation, please visit theaterhistorypodcast.net and follow @theaterhistory on Twitter. Just a note, theater is spelled THEATRE in our website URL, and it's spelled TER at the end in our Twitter handle. Our theme music is The Black Crook Gallop, which comes to us courtesy of the New York Public Library Libretto Project and Adam Roberts. Thanks as well to Tip Kress, who designed our logo. And finally, thank you for listening.